Earlier this year, a sexual harassment case was reported at India's largest software and IT services company. Women employees at TCS's Nashik BPO unit began filing FIRs alleging not just harassment but also religious coercion and systemic bullying by team leaders who had effectively seized control of the office. Nashik police deployed 6 undercover female officers, registered 9 FIRs, and arrested 7 accused, including a manager. Now, a report from the National Commission for Women's Fact-Finding Committee has confirmed pervasive harassment, zero POSH Act compliance, and toxic leadership that silenced victims through fear of transfers and termination. With India's IT sector under such a harsh spotlight, the case raises fundamental questions about whether prevention of sexual harassment is policy on paper or protection in practice. In this episode, I put some of those questions to Aparna Mittal, a leading equality, diversity and inclusion advisor and corporate lawyer with over 21 years of experience. She's the founder of Samāna Centre for Gender Policy and Law. Listen on, it's Thursday, the 21st of May. I'm Anirban Chowdhury. This is the Morning Brief. Hi Aparna, very warm welcome to the Morning Brief. Glad to have you with us again.
Hi Anirban, very nice to be here again. Thank you.
So we are talking about the TCS case. And a few weeks have passed and several things have come to light. Most importantly, the NCW report, which sort of validates a lot of things and is quite damning if you ask me. And I'd like your views also on it. So, first, what the report says is what most of us already knew, that the employees were aware, the colleagues knew, the leadership knew. How do you see this? This is quite a chain of silence running through the whole episode, right?
Yes, I think now that the NCW report is out for public viewing, things are a little bit more clear. From what we read of the report, it seems to be a complete opaque black hole of sorts, the workplace. It seems that a few people were perhaps in operational control of the branch. In any company or organization, there are many stakeholders. There are employees. It appears the employees were perhaps either unaware or scared or simply disengaged. In matters of gender-based violence, we focus on bystander intervention, that somebody around you will have the good sense and the courage to step in and intervene and ensure that horrible thing is not happening anymore and give you whatever support or help you need to navigate the process. It seems that there was no bystander intervention, which takes me back to what I was saying, that even people around them, the other employees, either there was lack of awareness or fear of retaliation, which basically makes it a vicious cycle of sorts. And then if we think of the managers, the HR, team heads, leaders, if they knew and they did nothing, it's appalling to say the least. Or it could also be that they knew, but they were also scared and threatened. But what we are looking at now, it seems to be there is complete dereliction of professional and even moral duty. And the victims have really been at the receiving end of what seems to be concerted, repeated offenses across multiple aspects for a long period of time.
Understood. Okay, now also, there are emails, there are chats that have come to light, there were internal warnings. Does any of it matter if the victim actually did not file on time?
Anirban, if you look at the kind of allegations that have come forward, there are multiple instances here. They allude to different kinds of wrongdoing. Some are related to sexual harassment, some are related to workplace harassment, and there are multiple forums and avenues for redressing these complaints. We're not just talking about POSH, we're talking about POSH, we're talking about internal code of conduct, which most large corporates in India have today. And we're also talking about the Indian criminal law system, which clearly has a lot of behaviors prohibited as offenses. So it's only within POSH that there is a strict timeline. The other two, whether it is an internal code of conduct or it is a criminal law, it typically do not have a timeline. And many of these are matters where a whistleblower could have come forward. It did not have to be only the victim who had to raise their hand and seek redressal. Especially in listed companies, there are whistleblower mechanisms. For a police FIR, anybody can go to the police and say, look, this crime is happening at this place, please intervene. So it is not just about, the timeline of POSH having been not met. It appears that the other avenues as well were either not accessed or there was no response at the appropriate time.
You got it. Now, the other thing that the NCW report says is that younger employees, especially Gen Zs, were susceptible or more susceptible to the kind of influence being exercised here. I mean, that's sort of a no brainer, but what is the underlying sort of concern that jumps at you from this finding or observation?
I think it was quite stark for the NCW report to have specifically mentioned this. I'm not surprised, Anirban. As you said, it's a no-brainer. Younger members of the workforce often have the least bargaining power and leverage. They can, unfortunately, they are the easiest to exploit and abuse. It can be, physical exploitation and abuse, economic exploitation, emotional exploitation, psychological exploitation and abuse. If there are specifically no checks and balances at a workplace. Many of these are often, first time workers. So there is no awareness or reference point to assess a comparative standard. Oh, this is not what happened in my previous organization, or this is not okay. This should not be happening at a workplace. We find that muscle memory is simply not there. And what makes youngsters in any, corporate chain, so to speak, the most vulnerable of the vulnerable is that because they are at the entry level, they are the most scared of retaliation or job loss, and they become the easiest to manipulate or mentor them in the wrong direction. The reason there is regular insistence on documented policy, trainings, awareness, posters, just setting up helplines, ombudspersons, and these are typical things large corporations do. It's done so that the benefit of knowledge, that what is okay and what is not okay, you don't have to be a privileged person in the corporation to find that knowledge. That knowledge should reach every person in the workplace, especially the youngest. And having said that, since the NCW has called this out, it appears that even that basic minimum to build the capacity and safeguarding of the younger members of the profession was unfortunately not done here.
The report also uses the word governance deficit. How do you see this?
Absolutely. I think I resonate from what they say because it seems to be a systemic failure of policy, systems, processes, culture, and how there are either no checks and balances or the checks and balances were futile and led to no benefit or any kind of safeguarding at the organization. I mean, one is a failure of system and process. There are multiple reporting lines and avenues. There is a she-box set up by the government. I'm sure large corporations like the one we're talking about has internal reporting lines, helplines, whistleblowing lines. In companies of this scale, under law, there are multiple levels of both internal, statutory, and compliance audits. And many of these have to be done by a credible third party. So it seems that the audits have not picked up not just matters of culture, but also matters of compliance, where there was wrongdoing and there was, systemic exploitation, and nothing has really come to anybody's knowledge. What shocks me even more, and I think a lot of us are drawing now, more forcefully from what the NCW report has said, that, this is actually a listed company. A listed company in India has very high thresholds of corporate governance. And for them to not be in place or perhaps be in place but not work, I think it is a calling of sorts to corporate India to wake up and really see what's happening in the organization.
Okay. Rape on the pretext of marriage inside a workplace hierarchy. At what point do you think does consent lose meaning in such an example?
I think in general parlance also, when we look at consent, and especially in matters of gender-based violence, we look at, willing consent and, informed consent. But the moment one of the persons, and especially the perpetrator, is in a position of authority, the consent has no meaning. you can pretty much assume that the consent is not in fact real or free or willing, or has been, taken under some kind of express or implied pressure, or what we call give and take. What the law does, and I mean both practically and through the letter of the law and policy, is that people who are in a position of authority or in a fiduciary relationship, they have a higher duty to discharge. It is really, the burden is on them to prove that they did not misuse their authority. They did not do something which, used that ostensible authority over somebody else to make them submit to the wrongdoing they were trying to perpetrate on the other person.
Let's get to the legalities of it, and things are clearer now, possibly because the report vindicates a lot of what legal experts would have already said. Now, the report recommends charging the accused under Section 299 of the BNS, that's the Bharat Nyaya Samhita, deliberate acts to outrage religious feelings, and this is alongside the POSH Act. How does this really work? And to me, this would make things cumbersome for the victim to. But I mean, you tell me what you think.
I think from what we are reading as the instances that have unfortunately occurred, multiple offenses under the criminal law are also made out. They have talked about sexual harassment, they've talked about stalking, they've talked about outraging the modesty of a woman, they've talked about, sexual intercourse with a person in authority, and also what you've just talked about, 299, which talks about, hurting the religious sentiments of a person. I think in whenever a criminal law is invoked, the police will investigate and comprehensively do their job. If the offense is proved, and a lot of evidence, etc., will have to be looked at, there will be eventually some conviction of the perpetrators. I understand, Anirban, your question that any investigation, in fact, whether it is a investigation under civil law or criminal law, invariably it is cumbersome for the victim because the victim has to, in a way, relive the trauma while giving out the narrative and answering questions and pulling out evidence to prove what they have had to go through. But I think the process must be followed. I mean, there is a reason we talk about integrity of process, so that there is fairness towards both sides of a particular story. And I think to reduce the intersectional burden on a victim, there is a focus on a victim-centric and sensitive approach, which means that, there are many international, global, and domestic protocols on how to run a proceeding which is sensitive to the victim, like simply not bringing the victim and the perpetrator face to face. So there is no, altercation or, a face-to-face confrontation between them. What is the tone and tenor of the investigating authority? Is the victim being shamed, or is the burden of the crime being put on the victim rather than the perpetrator? So I think if the investigating authorities, internal and external, are well trained and they approach the matter with some sensitivity, they are to some extent able to reduce the inherent burden on the victim.
Got it. The NCW has also found that TCS ran a single shared IC for both Pune and Nashik, which it has said is a direct violation of the Act. What does that really say about how the POSH Act is actually being monitored at the ground level, even at a company of that level?
I think, to be honest, I have been very skeptical about ground level monitoring of any sorts when it comes to POSH, especially by the government. Internally, there are many mechanisms, as I have talked about. There are audits, there are compliance audits. Under the Companies Act, the board of directors has to sign an affirmative statement in the director's report that ICs have been set up. So what we're actually looking at is that directors have probably signed it without ensuring that this has actually been done. So apart from those legal misses, I think even from the government's end, I have seen that ground level monitoring on the POSH Act is not something that has happened extensively in the past. It was only last year, after the Supreme Court judgment, that the SheBox portal was relaunched, where ICs of every workplace in India have to be registered. You'll be surprised that even today, and I checked the data before our podcast today, only 44,000 government ICs and 31,000 something private sector ICs have been registered. This is not even maybe 1% or 2% of the workplaces of the ICs we have in India, so to speak. So I have been very skeptical about ground level monitoring. In the past, I think especially in states like Maharashtra, there has been a push for state level audits through the labor commissioners, through other women and child department officials, etc. But if you look at the expanse of India, it makes me wonder, how will all of this really happen? They have to really come up with some technology based credible mechanism where there is actual ground level monitoring, not just of the year end filings, which are post facto filings, but also on day to day compliance on a matter of this nature.
But the fact that it happened in a non-metro satellite office, what does that say about the effectiveness or the efficacy of POSH in BPOs and satellite offices specifically? Is it failing there?
I think I wouldn't generalize. I have seen, small companies who have such brilliant levels of corporate governance, in spite of, multiple satellite or small offices across the globe. And I have seen very large companies, stellar, big branded companies, which I interact with. I advise them on how to clean up the system because they don't have even basics in place even today, or there is a heightened misunderstanding or misinformation about what needs to be done. I think more than the size and the brand, it really speaks on, whether they have worked with good or bad or lack of any kind of legal advice at all. Whether a lot of posh in India, and I see it, is being implemented through, WhatsApp messages, and somebody has interpreted something somewhere. There is no credible, access for people to go and actually treat this as a matter of legal compliance, where they must get credible legal advice and create comprehensive systems which institutionalize safeguarding and put in the checks and balances in place.
All right. Okay. Two final questions. One specific to the company and the other about India Inc. overall. Now, the report says that the IC's failure to act must be aggressively, and I am quoting the report here, must be aggressively punished to set an example. Do you think that'll happen? In your experience, has that kind of accountability ever actually happened in corporate India?
So whether it will happen, I think Anirban, time will tell. Whether I have seen that kind of accountability, yes. There have been many cases in India across civil and criminal jurisprudence where severe penalties and even imprisonment has been awarded to the perpetrators. And again, there are two kinds we are talking about. There are people who are directly culpable, the people who did that act of wrongdoing, they have been sent to jail, compensation has been awarded to the victim. But we have also seen cases of vicarious responsibility, where the management has been penalized for negligence or for not doing what they were supposed to do. To give you one example, the Madhya Pradesh High Court a few years ago, there was a large hospital in Madhya Pradesh which did not set up their IC. And the lady was sexually harassed, and she went to court saying that now I have no avenue to file a case. Of course, I have to face this kind of wrongdoing in the workplace, and my redressal mechanism has not been provided. Apart from the penalty under the law, which may have been 50,000 rupees, the court awarded 25 lakhs compensation, which the company had to pay to the victim. And there are many cases in corporate India as well, including on matters of POSH, where the Ministry of Corporate Affairs has also penalized directors for misstating compliance on a director's report on matters of sexual harassment. So I think, really, if the law is to take its course and there is a conviction or there is a final proof in terms of what has happened or not, where there is clear intentionality and clear proof, there are many precedents across civil and criminal jurisprudence where not just the actual perpetrators, but the managements have also been held vicariously responsible for negligence or for not doing what they should have done in a timely manner.
And finally, Aparna, what advice do you have for listeners? By listeners, I mean company executives or HR executives that are listening to this episode. What can companies really do to enable better POSH awareness and compliance?
I think, firstly, I think this has to be understood as a real matter of human, physical, and psychological safety, which is the duty, of the employer to ensure for its employees. And, what can they do? We'll take another podcast, but I will try and keep it brief. It has to be a host of measures, a robust policy, extensive training and culture building initiatives across cadres in different languages for employees, managers, leaders, extensive capacity building of ICs. And then, there can be a host of comprehensive internal assessments, audits to really preempt issues and ensure there is forward looking compliance. For all our clients, and I'm just giving one example, we have now trained them enough and put systems in place that even the largest of our clients, the moment a new lease is signed or a new premise is on their records, we get a notification and we put the compliance and get the resolutions passed and the compliance done in advance. So it's about system building. It's about putting a process in place which is not individual specific. And lastly, I think it's the attitude I have seen. There is a constant chalta hai attitude, an attitude to brush it under the carpet or apathy or can't be bothered. I think people have to understand that this is not just a legal risk. This is a business risk, and it can lead to severe goodwill and brand damage. And the only way for companies to do better is to adopt a zero tolerance approach. So I think it really starts from the top, the board of directors, the C-suite level, the key managerial person. They have to understand that the buck stops at their table. There is vicarious responsibility, morally and otherwise, and they have to put systems in place in advance to avoid any kind of legal, business, and goodwill ramifications for their organization.
Aparna, thank you so much.
Thank you for having me, Anirban. Always wonderful chatting with you.
The TCS Nashik case is a mirror. India's boardrooms have celebrated POSH compliance as a checkbox for over a decade. This case demands that we ask who is auditing the auditors. There will be more revelations, hopefully some action, and we will bring them to you in subsequent episodes. That's it for today. This episode was produced by me, sound designed by Amrit Reggie. Keep listening to The Morning Brief wherever you get your podcasts. Stay tuned.